Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Some complicated cases this week, spanning the spectrum of unique forms of relief, complicated nexus analyses, and stinging dissents. It's a good one, everybody. Also thought I'd mention, the Ninth Circuit denied a motion for rehearing en banc this week and slightly amended its October 2020 decision in Velazquez-Rios et al. V. Barr, the case about the retroactivity of Cal Penal Code Section 18.5, discussed on episode 27 of the podcast. So bummer there. On to the show. The first case this week is Oliveira v. Wilkinson, published by the First Circuit on February 22, 2021. This case is about INA Section 245I adjustment of status, a subject we still have not yet discussed on the podcast because immigration law is nuts. And it's also about my favorite BIA case titled Matter of Butt, because I am a child. So, INA Section 245I. This is a form of immigration relief that technically expired in 2001. It's an adjustment of status statute, similar in many ways to the current General Adjustment of Status statute and INA Section 245A, but with some very important differences. For example, unlike INA Section 245A, Section 245I does not require a lawful admission or parole into the United States to adjust status. So individuals who entered unlawfully can adjust under Section 245I. And Section 245I is not subject to the bars outlined at Section 245C. So, for example, non-citizens seeking to adjust status under Section 245I based on an employment petition can have lapses in their immigration status. It's a great provision that Congress should never have gotten rid of. But they did, and it's gone. But here's the catch. Non-citizens who are the beneficiaries of I-130 family-based petitions, I-140 employment-based petitions, or labor certifications filed with the Department of Labor or former INS on or before April 30th, 2001 can, provided that other criteria are met, still adjust status under INA Section 245I today. I currently have such a case in immigration court. What's more, even if the non-citizen no longer qualifies to adjust status under the initial timely 2001 petition, they can do what we call grandfathering and adjust status today based on a new labor cert or a new petition, provided that they had a qualifying labor cert or a qualifying petition filed for them on or before April 30th, 2001. But here's the other catch. To benefit from all of these nice Section 245I provisions today, the April 30th, 2001 or earlier petition or labor cert must have been, quote, approvable when filed, end quote. And that is what this case is all about. Mr. and Mrs. Oliveira are from Brazil and entered the U.S. on tourist visas in 2000. As the clock on Section 245I relief was winding down, Mr. Oliveira learned about it and hired a South Florida attorney to assist him to benefit from the provision. With the assistance of this attorney, and with the attorney acting as an agent for the very same sponsoring company itself, called NF Business Corporation, the corporation filed a labor cert for Mr. Oliveira for the position of clerk typist at some point before April 30th, 2001. The attorney who did all this was then disbarred for assisting his business partner in the unlicensed practice of law. Then another attorney took over the case, but failed entirely to keep the Oliveiras updated about what was happening with the labor cert. Turns out the labor cert was never approved by the Department of Labor, and Mr. Oliveira never worked for the company. The Oliveiras were then served with notices to appear in 2004 and placed in removal proceedings. For reasons that are just remarkable and unexplained, the immigration case was still ongoing 11 years later when, in 2015, a new company, the Boston and Maine Fish Company, filed a new labor certification for Mr. Oliveira. And so, the Oliveiras applied for I&A Section 245I adjustment of status before an immigration judge in 2016. This decision really does have everything. The immigration judge denied, holding that the NF Business Labor Cert from 2001 was not approvable when it was filed, meaning that Mr. Oliveira and his wife could not take advantage of Section 245I relief through the Fish Company Labor Cert. The regulations require that for a 2001 or earlier labor certification to be approvable when filed, the labor cert must, quote, 1. Be properly filed, 2. Be meritorious in fact, and 3. Be non-frivolous, end quote. Here, the IJ found that the NF Business Labor Cert from 2001 failed the second prong, meritorious in fact, because Mr. Oliveira didn't really produce documents or testimony to show his relationship to that corporation, and he didn't really explain why that 2001 labor cert had merit. The IJ did not, however, discuss the seminal and very descriptive 2013 BIA decision titled Matter of But, wherein the BIA explained exactly what was required for a labor cert to be deemed meritorious in fact. On appeal in 2019, the BIA was not going to be caught with its pants down and relied on a significant amount of matter of but. Nevertheless, the BIA did affirm the IJ. The BIA also denied the Oliveira's motion to remand based on alleged new evidence of the merit of that NF Business Labor Certification from 2001. On petition for review, and despite the BIA's lengthy discussion of matter of but, the First Circuit held that the BIA applied the incorrect standard to determine whether the NF Business Labor Cert from 2001 was indeed meritorious in fact or not. Generally, to be meritorious in fact, a labor cert must have been approvable, quote, under the standards in effect at the time it was filed, end quote. Here, the First Circuit held that regardless of which party has the initial burden under matter of but, quote, the ultimate subject of the inquiry must always be whether a labor cert should have been approved by the Department of Labor at the time and under the circumstances in which it was filed, end quote. Here, the IJ and the BIA failed to judge the NF Business Labor Cert by the Department of Labor's standards from 2001. The BIA also particularly erred by basing its decision on a perceived lack of employment relationship between Mr. Oliveira and the sponsoring corporation at the time that the labor cert was filed. Because as matter of but itself recognizes, the beneficiary of a labor cert cannot become an employee or enter into an employment relationship until after the labor cert is approved. So due to these reasons, the case was sent back to the BIA so it could get to the bottom of the meritoriousness of the labor cert under matter of but. Okay, I'm done with the puns. Congratulations, Stephanie Marzouk, for petitioners. Lots of stuff discussed here, so let's just move right along. After all, I'd hate to fall behind. And that is Oliveira v. Wilkinson. Next, we're going to head to the BIA for matter of LLP. This is a case about another unique form of relief, this time special rule cancellation of removal under I&A Section 240A, B2, also known as VAWA, or Violence Against Women Act, cancellation of removal. Like normal non-LPR cancellation of removal, special rule cancellation of removal provides a path for non-citizens to obtain green cards. But in the case of this form of relief, only those non-citizens who have been abused or suffered extreme cruelty from a U.S. citizen or LPR spouse or parent. If a non-citizen meets the criteria, it's a very favorable form of relief. For example, unlike the 10 years continuous presence required for non-LPR cancellation of removal, VAWA cancellation only requires 3 years. And service of an NTA doesn't stop those years from accruing. Again, very favorable. So the VAWA is a bit of a misnomer, because men can of course be abused too. Indeed, Mr. LLP is a man, and the BIA used an acronym for his name because of the nature of the case. He was placed in removal proceedings in 2006 and applied for VAWA cancellation of removal, which the IJ denied. And here, the BIA affirmed that denial. See, at the time of the abuse, Mr. LLP was, appropriately, in a partnership, albeit a common law marriage, and his common law spouse was neither an LPR nor a USC. But she did become an LPR after the abuse and after the common law marriage ended, and she was an LPR at the time that Mr. LLP filed for VAWA cancellation of removal in immigration court. The IJ and the BIA said that didn't matter. The BIA held that the VAWA cancellation statute was ambiguous as to when a spouse or a parent must be an LPR or a U.S. citizen for their abuse to qualify a victim for VAWA cancellation. Considering the, quote, broader context of the statute, end quote, and congressional intent, the BIA held that the spouse or parent must be an LPR or a U.S. citizen at the time of abuse or extreme cruelty, and that the abuser must have been a spouse or a parent at the time of abuse. This is because, in part, the whole point of VAWA was to, quote, free abused spouses who are married to United States citizens or lawful permanent residents from the fear that remaining in an abusive marriage is the only way to obtain lawful immigration status, end quote. So, because Mr. LLP's spouse was not a lawful permanent resident at the time of the abuse, he does not qualify for special rule cancellation of removal. But the BIA did grant Mr. LLP's motion to remand so that he could apply for regular non-LPR cancellation of removal under I&A Section 240AB-1, due to the fact that his 2006 NTA, get this, didn't have the date and time of his initial hearing. Now, in pretty much every circuit, that wouldn't matter, because pretty much all circuits and the BIA have held that a subsequent notice of hearing stops the clock to establish the 10 years continuous presence required for non-LPR cancellation. But not in the 10th Circuit, where these proceedings originate. The 10th Circuit has held that under the statute, only an NTA with the date and time of the first hearing can stop the clock. I tend to agree. The Supreme Court will soon decide. So hurry up and get that individual hearing, Mr. LLP. Here are some more observations. In this case, the BIA is relying heavily on the I&A's statutory framework as a whole to resolve the apparent ambiguity regarding when an abuser must hold lawful immigration status for a victim to qualify for VAWA cancellation. And when it comes to statutory interpretation, the I&A's framework means many things to many people. So use the tool, practitioners, like the BIA did. Next, here's the respondent-friendly flip side of the BIA's holding that what matters is whether the spouse holds lawful status at the time of abuse. Quote, the spouse or parent may later lose his or her citizenship or lawful permanent resident status. yet the applicant does not lose the opportunity to apply for special rule cancellation, end quote. Indeed, even a later divorce will not preclude a grant of VAWA cancellation under prior BIA precedent. So remember that. And finally, although ultimately unsuccessful, it's worth noting that this entire decision assumes that even a common law marriage will qualify a non-citizen for VAWA cancellation so long as the common law spouse is an LPR or U.S. citizen at the time of abuse. And that is matter of LLP. Heading back to the First Circuit, we have Molina-Diaz v. Wilkinson, published on February 25, 2021. This case is about credibility and corroboration. Ms. Molina-Diaz is from Honduras and has entered the U.S. unlawfully on 2 occasions. She was summarily returned to Honduras in 2006 when she was apprehended because she said that she didn't have a fear of return. But in 2009, on her second entry, she said that she had a fear in Honduras due to her involvement in the anti-government land reform organization known as MUCA, also known as the United Movement of Peasants of Aguian, or the United Movement of Farmers of Aguian. On her second entry, DHS found that Ms. Molina-Diaz had a reasonable fear of persecution, and so placed her in withholding-only proceedings. She was ineligible for asylum because, I assume, DHS reinstated the prior order of removal from 2006. In her affidavit before the immigration judge, she documented her political anti-Honduran government activities with MUCA, including meeting ousted President Manuel Zelaya at the Nicaraguan border. She also described clashes that her group experienced with the Honduran police and military. She also claimed that she was raped by an anti-Zelayan Honduran soldier and had had a child by that man, and that she feared torture and death upon her return. The IJ denied withholding of removal under the INA without expressly finding that Ms. Molina-Diaz was not credible, and the IJ did not address protection under the Convention Against Torture at all. The IJ also held that Ms. Molina-Diaz had not sufficiently corroborated her claims. On appeal, the BIA held that, quote, the IJ's findings constituted an adverse credibility finding that was not clearly erroneous, end quote, and that the IJ properly did not address cat protection, even though Ms. Molina-Diaz checked the cat box in the I-589 and mentioned a fear of death and torture in Honduras. The BIA also denied Ms. Molina-Diaz's motion to reopen. The First Circuit reversed. It held that an IJ simply having, quote, serious doubts, end quote, of Ms. Molina-Diaz's credibility, combined with a statement that such doubts, quote, could have been overcome with appropriate corroborating evidence, end quote, is not an explicit adverse credibility finding that the BIA can affirm. According to the First Circuit and other circuits, this, quote, reluctance to make clean determinations of credibility appears to be a disturbing feature of immigration cases, end quote. But here's the thing. Without a, quote, clean determination of credibility, end quote, the INA provides Ms. Molina-Diaz with, quote, the rebuttable presumption of credibility on appeal, end quote, and so the BIA erred by not giving her that presumption. Not only that, where presumed credible, matter of lack requires that an IJ give the non-citizen, quote, an opportunity to explain why he could not reasonably obtain such evidence, end quote. The IJ did not provide this opportunity. And under such circumstances, quote, an IJ cannot explicitly find an applicant's explanation inadequate without first offering her an opportunity to provide such an explanation, end quote. The First Circuit also held that the IJ and the BIA erred in failing to even consider Ms. Molina-Diaz's request for cat protection. The BIA had faulted Ms. Molina-Diaz for not requesting that protection in her affidavits submitted to the IJ, but she did check the cat box in the Form I-589, and in any event, as the First Circuit recognized, the BIA held in matter of NM that where, like here, a non-citizen mentions a fear of torture, even without checking the cat box in the I-589, an IJ has a duty to consider cat protection. Congratulations Nancy J. Kelly, John Wilshire Carrera, Harvard Immigration and Refugee Clinic, and Greater Boston Legal Services for the win. And that is Molina-Diaz v. Wilkinson. Moving right along, we have Zelaya-Moreno v. Wilkinson, published by the Second Circuit on February 26, 2021. Similar to the decision 2 weeks ago, this is another big one from the Second, ruling against the non-citizen on asylum and related relief, this time related to gangs. And like the decision 2 weeks ago, Judge Pooler dissented. Mr. Zelaya-Moreno is from El Salvador and entered the U.S. in 2014 at about 21 years old. He was placed in removal proceedings and applied for asylum and related relief. As the basis, he testified that MS-13, it appears, demanded that he join the gang, but that he refused because he opposed the gang, believing it harmful to El Salvador. He was beaten and told by the gang members to either join or leave town. He did neither, and 2 months later, 3 men in police uniforms came to his home, beat him, drove him to an MS-13 house with 10 gang members, and watched as the gang beat him severely after he refused to join again. These men dressed as police then returned Mr. Zelaya-Moreno to his home themselves, in uniform, and he sought treatment at a hospital. He fled a few months later after receiving death threats from the gang. Before the immigration judge, Mr. Zelaya-Moreno submitted a lot of evidence to support his claim, and the IJ found him credible. But the IJ denied on nexus, finding that Mr. Zelaya-Moreno's alleged anti-gang political opinion was not one central reason for the harm he suffered. Rather, the IJ concluded that it was because he refused to join the gang, irrespective of what he thought about gangs personally. The IJ also denied cat protection, holding that Mr. Zelaya-Moreno failed to establish that the Salvadoran government or police were still looking for him, or that the government would acquiesce to MS-13's torture. On appeal, the BIA took a different path to denial. It determined, flat out, that, quote, expressing an opinion against a gang is not expressing a political opinion, end quote, at least when it occurs following attempted recruitment. So the BIA held that Mr. Zelaya-Moreno failed to assert a cognizable protected ground to asylum or withholding completely. And that is what the Second Circuit largely affirmed. Rough. To be fair, the Second Circuit majority did say that, quote, political opinions may be intertwined with ostensibly non-political issues, end quote, and that the question of whether a belief or action at first blush is actually political is, quote, highly context-dependent and fact-intensive, end quote. Here, however, Mr. Zelaya-Moreno's refusal to join a gang in El Salvador, quote, without more, end quote, does not constitute a political opinion. Rather, his, quote, disagreement with the gangs is no different than any other person who disapproves of criminal elements in his or her society, end quote. As to cat protection, the Second Circuit also upheld the BIA's finding that Mr. Zelaya-Moreno did not establish that he would more likely than not be tortured, noting that he was not harmed in the 3 months after his beating and before he fled, and that his family members still live in El Salvador unharmed. So, Mr. Zelaya-Moreno did not succeed, and as Judge Pooler recognizes in dissent, the result for Mr. Zelaya-Moreno may be horrendous. But for what it's worth, there are some nuggets to be found. First, and according to the Second Circuit when it comes to political opinions, quote, to guide this inquiry, we may look at whether the opposition to corruption transcends self-protection and represents a challenge to state-sanctioned modes of official behavior, end quote. I have read quite a few expert reports for countries such as Russia that would appear to meet this standard. And really, this decision does not preclude gang-based political opinions entirely. In fact, the majority chastised the BIA for doing so in this case. So, practitioners, so long as you can show, as the majority analogizes with the FARC in Colombia, that the gang in your client's country seeks to displace the lawful government or otherwise, quote, espouses political views, end quote, you may succeed on a political opinion case. And also, under the majority's own words here, quote, whistleblowing or campaigning, end quote, against gangs, even in El Salvador, might cross the line into political activities. Next, here's a gem from the Second Circuit agreeing with the Third Circuit's statement that in appropriate societies, there is, quote, little doubt that feminism qualifies as a political opinion, end quote. Indeed. Finally, like 2 weeks ago, Judge Pooler in dissent is having none of it. I leave you with one of her final paragraphs, in full, in which she relies on nonsense statements by former President Trump from 2018, asserting that House Speaker Nancy Pelosi supports MS-13. Quote, Zelaya-Moreno expressed his opposition to MS in El Salvador, where that gang has a clear role in the political life of the country. The U.S. Department of Justice says such opposition is not political. Yet in our own country, where the threat of MS is arguably far lower, the former head of the executive branch, surrounded by top Department of Justice leaders, stood before the country and treated opposition to MS as a political distinction between him and his opponents. In other words, the prior leaders of the executive branch were comfortable treating their own opposition to MS as political, but not the statements of someone who challenged MS on its home turf, end quote. That is how you dissent, and it's an analogy I'll be making in gang cases going forward. And that is Zelaya-Moreno v. Wilkinson. Next is Sunuwar v. Attorney General of the U.S., published by the Third Circuit on February 25, 2021. This case is about protective orders, particularly serious crimes, and credibility. Mr. Sunuwar is from Nepal and immigrated to the U.S. in 2017 after winning the diversity lottery. And the diversity lottery really is essentially a lottery for the world, that if a non-citizen wins and is part of the select few chosen every year, allows that non-citizen to immigrate to the U.S. and become an LPR. Pretty remarkable. But in 2019, based on crimes committed against his wife, Mr. Sunuwar was convicted of first-degree felony strangulation under Chapter 18, Section 2718A of Pennsylvania statutes, and contempt under Chapter 23, Section 6114A of Pennsylvania statutes, for disobeying a protective order. Really bad police reports, too. He was sentenced to 11.5 to 23 months imprisonment for the strangulation offense. DHS placed him in removal proceedings and charged him as removable for a bunch of reasons. Mr. Sunuwar applied for asylum and related relief, claiming that if returned, he'd be forcefully recruited and then persecuted and tortured by the Maoist Party in Nepal, the communist-type political and violent entity in that country engaged in an ongoing struggle against the Nepalese government. He and his wife testified in support of the application and in support of the case. The immigration judge denied everything, and found that the strangulation conviction was a particularly serious crime for both asylum and withholding of removal purposes, making Mr. Sunuwar only potentially eligible for deferral of removal under the Convention Against Torture, which the IJ denied based primarily on a finding that neither Mr. Sunuwar nor his wife had testified credibly. The BIA affirmed. And so did the Third Circuit. First, it found that indeed, Mr. Sunuwar was removable under at least INA Section 237A2EII, the removability provision for violating a protective order. Relying on the Seventh Circuit, the Third Circuit held that, quote, for an alien to be deportable under this provision, 1. There must have been a protective order entered by a court. 2. At least one portion of that order must have involved protection against a credible threat of violence. And 3. A court must have determined that the alien engaged in conduct that violated that portion, end quote. Here, the Third Circuit found that all three elements were met when Mr. Sunuwar violated the no-contact protective order by writing letters to his wife from prison. The Third Circuit rejected Mr. Sunuwar's argument that simply writing letters couldn't make him removable because, according to the Third and many other circuits, what matters is that the protective order itself protects against a credible threat of violence, not that the violation of that order necessarily involve a threat of violence. The Third Circuit then found that indeed, first-degree felony strangulation in Pennsylvania, and at least in this case, is a particularly serious crime that bars asylum and withholding of removal. It applied the BIA's test from matter of NAM, whereby a judge must, quote, first decide whether an offense's elements potentially bring the crime into a category of particularly serious crimes, end quote. Only if it does should a judge then go on to determine whether the sentence imposed and the facts of the specific crime are particularly serious. The Third Circuit affirmed that first-degree strangulation satisfies the first prong, as the statute is considered in Pennsylvania a, quote, violent crime, end quote. Then, looking to the facts of the crime, which are really bad, the Third Circuit held that the agency properly disbelieved Mr. Sunuwar's version of events and found that the crime was particularly serious. As to the denial of cat deferral, the Third Circuit affirmed that too. First, it affirmed the adverse credibility finding, deeming the main inconsistencies between Mr. Sunuwar's testimony and his I-589 sufficiently glaring, and also considered inconsistencies between his and his wife's testimony as compared to the probable cause affidavit created by a police officer the night of the strangulation offense. The Third Circuit rejected Mr. Sunuwar's attempt to blame the I-589 inconsistencies on his prior attorney, and additionally held that a reasonable fact finder could have believed the probable cause affidavit over the in-court testimony, at least in these specific circumstances. Mr. Sunuwar therefore lost. I have two more things to say. For what it's worth, in conducting the matter of NAM review, the Third Circuit did agree that a sentence of 11.5 to 23 months, quote, was relatively minor compared to the maximum sentence authorized by applicable law, end quote. And there aren't many cases to cite to for this prong of the NAM analysis, so remember this case. Finally, and not gonna lie, it was hard to be sympathetic to Mr. Sunuwar in this one. Doesn't change anything really when it comes to the law or the practice pointers, but this case served as a reminder to me that the facts of a case, good or bad, can sometimes color the legal analysis. Beware, because of course, judges are humans too, and often must fight this same feeling. And that is Sunuwar, the Attorney General of the U.S. Finally, we come to Lazo v. Wilkinson, published by the Ninth Circuit on February 26, 2021. This is a case about controlled substance offenses. Mr. Lazo was from Mexico and became an LPR in 1961, long time ago. He got in trouble for possessing cocaine in the 1980s. But Mr. Lazo got a second shot and got to keep his green card when an immigration judge granted him former 212C relief. 212C. But then in 1999, he was convicted of possessing a controlled substance under California Health and Safety Code Section 11350, and charged as removable for having been convicted of a law relating to a controlled substance under INA Section 237A2B(I). As we've discussed before, for an LPR to be removable for having violated a law relating to a controlled substance, under the categorical approach, the non-citizen's offense must necessarily involve a controlled substance listed in the federal controlled substance list. Like many states' crimes, a violation of California Health and Safety Code Section 11350 does not necessarily involve a drug listed in the federal controlled substance list, because California criminalizes possession of a bunch of drugs that the feds don't. That means that the only way a non-citizen can be found removable for having violated a law relating to a controlled substance, based on a violation of Cal Health and Safety Code Section 11350, is if the California statute is divisible as to the drug possessed. and if, under the modified categorical approach, the reviewable documents show that the non-citizen possessed the drug listed in the Federal Controlled Substance List. An IJ and then the BIA found that the statute is divisible as to the drug possessed, and reviewing the conviction documents discovered that indeed Mr. Lazo possessed, you guessed it, cocaine, which is listed on the Federal Controlled Substance List. And the Ninth Circuit agreed, relying heavily on its 2017 decision in United States v. Martinez-Lopez, which concerned the divisibility of California Health and Safety Code Section 11352. The Ninth Circuit placed great emphasis on the fact that apparently, in California, an individual can be convicted of two separate offenses if he or she possessed two separate controlled substances, indicating that the identity of the substance in California for crimes like these is an element rather than a means of committing the offense. Also, the jury instructions for this crime require a jury to fill in the blank, following instruction by the criminal judge, as to the identity of the controlled substance, further indicating that the identity is an element. And if it's an element, the statute is divisible as to the drug possessed. Mr. Lazo, therefore, is removable. But here's some stuff for your divisibility arguments. For what it's worth, the Ninth Circuit did categorically state that, quote, if, for example, a jury need not unanimously agree as to which of the listed alternatives was satisfied in a particular case, that is a clear sign that they are alternative means of committing one offense and not alternative elements of separate offenses, end quote. I've found that focusing on the jury instructions is often a more helpful method of proving that an alternatively phrased requirement in a statute is a means rather than an element. So it's nice to see the Ninth Circuit being clear on this as well. Also, and finally, as the Ninth Circuit notes in a footnote, if you're looking to analogize to a California drug crime that is not divisible, look to the Ninth Circuit's 2019 case in United States v. Graves. The divisibility analysis in that case appears to have turned largely on the fact that the statute at issue there, California Penal Code Section 4573.6, criminalize the possession in prison of, quote, any controlled substances, end quote, rather than a specific controlled substance. So maybe rely on the analysis in United States v. Graves if you get a different controlled substance offense and want to show that it is not divisible as to the controlled substance at issue. And that is Lazo v. Wilkinson. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.